We are back in session. We will now return to the violation cases recommended for letters of instruction or referral to the Attorney General's office. And it is our custom to hear a report on each of these. We will follow that. So let's first have a report on case number 2020-01, absentee ballot irregularities in various counties. No, 12. This report, by the way, is 87 pages long.
Yes.
Don't read each page.
No. I'm just gonna try to give an overview, and then if you want, I can go through. There's 17 respondents here. So, and I can kind of give a overall. So, this case involves absentee ballot signature irregularities. It involved numerous counties in Georgia and ballot applications and ballots that were rejected due to mismatched signatures. Overall, there were 17 respondents in the investigation, and it revealed the following. 39 absentee ballots were rejected due to the elector not signing their oath. 1 absentee ballot was rejected due to missing information on the oath envelope. 1 absentee ballot was not a mismatched signature. The ballot was not returned. 1 absentee ballot was rejected because the elector wrote the wrong date in the date of birth section. 1 absentee ballot was listed as rejected, but it was not rejected. 198 absentee ballot signature mismatches were not resolved. 69 applications for official absentee ballot signature mismatches were not resolved. 19 absentee ballot signature mismatches were resolved, and 62 applications for official absentee ballot signatures were resolved. So, I can go through each one of the violations that we saw, the citizens and the circumstance, if you would like. Board, Chairman, you want me to go through each one? I can do that if that's what the board.
Can you maybe go over a couple of representative samples of what you saw with respect to violations that you found? Okay.
So looking at the first individual, Mary Bryant. So during the November 6, 2018 general election, the Bartow County Elections Office received an application for official absentee ballot in the name of DeMarcus Bryant. The application was not signed in the name of DeMarcus Bryant. The signature on the application was Mary Bryant. The elector was found not eligible to receive an absentee ballot because of a signature mismatch. Lynn Christian. There is evidence to suggest she violated OCGA 21-2-318 sub C sub I, making an application for absentee ballot, and that during the November 6, 2018 general election, the Bartow County Elections Office received an application for official absentee ballot in the name of Theophilus Christian. The elector was found now eligible to receive an absentee ballot because of a signature mismatch. Lynn Christian advised during an interview she signed her husband's name to the application because he was not home to sign it. Denise Cobb. There is evidence to suggest Denise Cobb violated OCGA 21-2-385A, procedure for voting by absentee ballot, and that during the November 6, 2018 general election, the Burke County Elections Office received an absentee ballot in the name of Janelle Jones. The absentee ballot was rejected because of a signature mismatch. Denise Cobb stated during an interview she might have voted her son's ballot and signed his oath because he was away at college. So the rest of the potential respondents are very similar in nature to that, in which there was an admission, basically that they signed either an oath envelope or an absentee ballot application for someone else. And then they gave various reasons for that. Some of them were the person was not at home, the person was sick, and those type of things. So that's pretty much a representative of the rest of the 17 individuals that basically were listed as respondents. Now, there were some individuals, in looking at this case, this was a voluminous case, 87 pages. There's a couple of individuals, upon further review, that we're going to take a look further at, specifically one in which a mother indicated that her daughter might have signed it. So we're following up on that. Just found out that the mother has since passed. This has been 5 years ago, but we're still trying to track down the daughter. There's some other people that are part of this case that said, well, I might have, I can't remember, that type of thing. So those are the individuals that, you know, maybe an LOI, something of that nature. It's not enough as far as preponderance in some of these cases. And unfortunately, this is almost 5 years ago when this happened. So that's what we're kind of looking at with this case.
Can you tell us, because it says that this was instituted by the Secretary of State's office, and it does relate to a bunch of different counties. What was the emphasis or the impetus for these to be investigated? How did this come about that the Secretary of State's office commissioned the investigation?
Okay, there was a series of emails, I believe, during that time. Glenn, you want to come up here? Glenn Archie was the investigator. He's our supervisor in the Macon office at the time. He was the investigator who put this 87-page investigation together. So,
yes, Your Honor, back in 2020, we were asked to look at this particular election in 2018. Part of that election, I think there was a court order that came out from one of the courts in Georgia in reference to treating them as provisional ballots, in reference to signature mismatches and other things like that. And we were given spreadsheets of numerous counties in Georgia to follow up on. So we had to have the Atlanta office and the Macon office to cover all these counties and contact the election offices and get the documents. And then, of course, interview the voters. And like the deputy chief said, there are several people that were cited for potential violations. But during the ones I spoke with, there were some where the family member had a stroke. They were not aware that they couldn't sign their name. There were several of those involved in that, and I informed them that I would include that information in my report, and then the board would review it and make a decision case by case. But that's pretty much in a nutshell. We were asked to review it and see if they were cured properly by the counties and all that involved in that court order.
Okay. Well, we've all had a chance to go through this. It is lengthy. I would say I'm impressed with the amount of detail that you provided and the effort that you went with respect to each person. It's heartening to see that there's enough here for us to review to say that looks to me like the right conclusion that you reached as investigators. And so I appreciate all of your hard work on this. And I know that this took a long time to prepare. So thank you for that. And we appreciate it. Is there a motion with respect to this complaint?
Should I?
Pardon me? Sure. Which one?
Investigator, the family who was just here a moment ago, the one who she signed her husband's name from Bartow County, what's her name?
Lynn Christian was her name. Yeah.
So Lynn contacted me about a week ago. She is a voter in Bartow County about this case. She had been trying to reach out to the investigators, was not able to reach them to explain what was going on. She was here earlier, but had to leave. It was a hardship for her to make it down here today. They couldn't stay through lunch. But wanted to make sure y'all knew, and I offered to speak for her since she had to leave, that her husband wasn't home because he had a stroke. And she was allowed under law to request that ballot on his behalf because of that disability. And the application that she had to use was a postcard application from campaign. And back in 2018, the campaigns could use their own form for applications, and they were little postcards. You know, they had a name, an address, sign here if you want your ballot, and send it in, and you go ahead and send it in. They had no instructions for assistance, no instructions to request on behalf of another, no place to say, he has a disability, I'm going to sign on his behalf, and she did the best she could with her knowledge of the law. Understands now that that was the wrong way to do it. And of course, it's a moot point now. We can't do those applications anymore. Now, thankfully, every voter has, or every family member, the instructions in front of them to know what's legal, what's not, and the proper way to do it. But I did think it was important to note that the piece of paper she had in front of her only had one line to sign, no instructions for assistance, no instructions to request on behalf of another at a time that her family was in crisis. I just thought you'll want to know that. Thank you.
All right, thank you, Mr. Kirk. Ms. Gazelle?
I don't have a motion to make on this entire case because I think it's really important to differentiate between applications and ballots, because even in 2018, the law differentiated between who was eligible to apply for a ballot. So there may have been some technical errors by family members who in fact were submitted lawful requests but signed on the wrong line on an application or did not have the line to sign, versus those voters who signed the ballot on behalf of a family member, which is and was a violation of the law. So I think that we're going to have to address the respondents on an individual basis.
Well, if you've looked at the ballot people, why couldn't we make a motion with respect to them and refer the registration people back for further investigation?
I think the applications, I would move that those respondents who signed applications on behalf of family members simply receive a letter of instruction. So that's my first motion.
All right, is there a second to that motion?
I think we actually may have some respondents here who would like to speak.
I just have a question. You read my name off on Denise Cobb.
One second. What number are you? Your seat number. Okay, now try it. So you're the person I helped get your parking sticker this morning. No, that's all right. Got it?
Okay, I just wanted to see whether each person was going to get to speak.
You are. You can speak.
Okay, because
Well,
with
what's your name? Tell us your
I'm
name.
Denise Cobb. Janelle Jones was the person.
Okay, now wait a second, because it's. And what county are you from?
Burke County.
Denise Cobb?
Yes.
Got it. Okay. Go ahead.
And with my case, they said that I signed for my son to vote, but I actually the date they did the investigation, I was driving, so my son called, and I ended up speaking to my son, and he was he was replying whatever I said to the person that was there. He said it was somebody's from the voters board. So I thought that they was talking about the application for him to get the absentee ballot. And I did sign that. I signed one for him and one for my daughter to get one. Because he was going to, I'm sorry, I'm a little nervous. He was going to Albany State and she was going to Middle Georgia State. So I signed for them to get them. And when he said, did you sign? I thought he meant, did I sign the thing for them to get the applications? Because when I got the applications, I knew it was going to be too late for me to take them to the school. So I threw them in the trash. And I guess, I talked to my lawyer's wife, and she said that's something that I shouldn't have did, was throw them in the trash. I threw them in the trash for both kids, because I said I knew that they had to do it with their school, and I thought the school had to send some information saying that they was registered in school.
Well, just so that you're clear, the allegation is that the absentee ballot was signed, not the request for a ballot.
Yeah, and I didn't do that. I thought, because it had been so long, I was thinking when the people, because I actually was at a store and they asked me, did I have anybody that needed one? And I told them yes. I said, but my kids are at school, so I can't sign for them. And the lady said, you can, because you're their guardian, so you can sign to get their balance. And that's what I thought they were talking about when he called me on the phone, because I was driving. And I am really a nervous driver, but when I saw my son's name pop up, I thought it might have been an emergency situation, so I answered.
So what you're saying is that the conversation you had with the investigator, you thought pertained to a request for a ballot as opposed to the actual ballot?
Yes, and when me driving, that's why I said I might have got a little confused, but I kept thinking that they was talking about the application for that. And so I said, yes, I probably did. That's what I was telling my son, because I talked to my son, not the person that was at the house. But he told me that if he needed to talk to anyone, he would, but he had to work last night, so he couldn't be here.
Do you know who signed his absentee ballot?
I don't know, because I threw it in the trash. I didn't think that anybody would have, because it was him and my daughter. They both were away at school, so I threw both. I had two. I threw them both in the trash.
But if you threw the ballot in the trash, there wouldn't be any record to show that there was a mis-signing. So I think, if I'm right, this absentee ballot was actually returned.
It was
Yeah, that's why I
returned.
said I don't know what happened and how it would have got returned, because I had two. So it should have been him and my daughter that somebody would have did it for.
Right.
I don't know whether somebody went in there after me or whether it was because I live down the road from the landfill, so we throw our trash out there. Whether somebody might have went to the dumpster and got it, I don't know. But I know the only thing I signed for was them to get the paperwork to do them. And like I said, I knew I didn't have enough time because I thought everything had to be sent through the school. So I just threw them away.
Can I add something, Your Honor?
Yes.
When I spoke with their son in reference to this case, he told me at first that he was not registered to vote. But then I went through my documentation. I pulled off the road so I could pull my documents. I said, you registered through DDS. And then he sort of remembered registering to vote. Later on, I did talk with Ms. Cobb, and during the interview, I always make sure they understand I'm talking about either applications or absentee ballots. And when I asked her questions about the absentee ballot, that's when, at one point in the interview, she said she might have voted his ballot and signed his oath because he was away at college.
Your Honor, what date did I talk to him on? Because the only time I remember talking to somebody was when my son called me and I was driving, and I didn't talk to that person directly. I talked to my son, because I remember the person saying, like making him repeat himself, and that was it. I never spoke to anybody directly. The only time I spoke to someone directly was when I got my package in the mail. And when I called then, I told him, I said, I didn't say that I signed it. I said, I think it was a miscommunication. And they said, well, if you want to go back on what you said, then you can do that, but this is what we have in the paperwork. And I said, I never talked to anyone directly. I talked to my son, and my son was delivering the messages.
Did you ever talk to her son?
I did.
And what
I
did he say?
contacted- He advised me, like I've already said, he said at first he wasn't a registered voter, but then I informed him he was. And then he had no knowledge of receiving an absentee ballot or voting one. But it was returned in his name.
All right, any further questions, either of the respondent or the investigators? All right, thank you very much.
Thank you.
have to use that
I'll
one.
take yours, it's already on.
We know that one works.
I'm Catania Combs, and I received a letter.
Hold on for 1 second.
okay.
You would tell me your name slowly?
Last name is Combs, Catania.
Okay, thank you.
You're welcome. I received this letter a few weeks back, and it blew my mind, but I contacted the number that, well, I pulled up a number on the internet and called and spoke to Gil. Gil told me to reach out to, well, he transferred me to Mr. Archie, I think, the next day. And I spoke to Mr. Archie, and he asked me, did I ever get interviewed? And I said, no, I was never interviewed, but my grandmother was. In regards to signing their ballots, her and my grandfather, since he's since passed, he passed in November, so he's not here. But they did speak to my grandmother, but I've always signed everything for them. She has trembles, whatever. He couldn't sign because he had a stroke. And so I did let him know that, but he said that to get them new voter cards, get new voter cards and let her sign it best she can, and then when she does this again, then she can sign it herself. Because I do everything for her, legally, whatever it may be. And I didn't know that that was an issue. So, and that's what I wanted to say. But she's here if you need to speak to her also.
She being your
My
grandmother?
grandmother, Sarah Scott, I'm sorry.
I'm Ms. Scott, thank you for coming down. Any other respondents want to speak? Yeah.
I'm sorry, Mrs. Sarah Scott? I have a very quick question for Ms. Sarah Scott. Yes, it's fine. I'm so sorry to inconvenience you, but Mrs. Scott, did you in fact complete your ballot, the ballot that your granddaughter signed on your behalf? Did you complete your own ballot?
Complete your ballot that I signed for you.
As far as I know, I did.
Thank you, ma'am. That was the only question I had for you. I appreciate it. And thank you so much. I know it's a great deal of trouble coming down here, so I really appreciate that you all came down here for this.
Thank you. That's it.
Tanisha, before you get comfortable, I have a question for you, if you don't mind. Need you to come back up. Sorry.
If you hold that long enough, we give it to you.
So you've done research you need to do to make sure that in the future, you're going to do this the right way?
Yes, we are ordering new voter registration cards to let her sign it herself.
Okay.
So when this comes around again, next year, right? Yeah, next year, I'll just assist her. I won't touch anything. Whether her signature is scribbled, you can barely see it, that's just how it's gonna be. I'm not touching anything, ever.
So if we sent you a letter that said, don't do it again,
Oh, you
you're
ain't
not
gotta
going to do
worry
it
about me,
again?
no.
So that'd be a good solution from your mind, right?
Yes.
Okay.
Yes.
Thank you.
How about this? Oh, no, wait.
Any other respondents care to speak? I suggest that we maybe deal with these two on separate motions. Is there a motion regarding Denise Cobb? Is there a second? It's been moved and seconded that respondent Denise Cobb's complaint against her, that while we find a violation, we send her a letter of instruction admonishing her to follow the proper procedures and not to sign ballots on behalf or even registrations on requests for absentee ballots on behalf of other people unless she follows the procedures that allow that to be done. Is that what everybody understands the motion to be? So that's the motion. All those in favor say aye. Opposed, no. That passes.
Your Honor, can I say something about 3 other respondents? They contacted me, but they weren't able to make it here. It was Miss Whitfield, also a Miss Scurry, and also a Deborah Black. They had similar circumstances where one is the daughter of the mother. She suffered a stroke. That's the reason why she signed hers. She also had power of attorney. Also, Miss Black, similar situation. There was some medical and physical disabilities, and also Miss Whitfield.
With,
I move that the case involving Katie Whitfield, Deidre Scurry, and Deborah Black,
Yes, sir.
that we similarly find a violation, issue a letter of instruction.
well, should we add Ms. Combs to that?
Yes.
Or Tanisha Scott?
Oh, yeah, I'm sorry. Thought we already. Correct. Yes, Mr. Chairman, sorry.
So for,
And Lynn Christian from Bartok.
Yes, that one too, I'm sorry.
Christian? Lynn Christian is yours?
Yes.
Yeah, accept those friendly amendments, Mr. Chairman.
where's Christian?
On the front page.
All right, then for respondents, Lynn Christian, Denise Cobb, where do we do Denise Cobb? Katie Whitfield, Tanisha Scott, Deidre Scurry, Deborah Black. The motion is to find a violation, but to send letter of instructions requiring them to. Where? Oh, okay.
My name is Larry Corbin.
Okay, can you? Let's try that, see if that's right. Keep just talking to the microphone. Okay, try it again.
1, 2, yeah, okay. I got one from, this evidence suggests that Larry Corbin violated the OCGA -28385.
And what's your name?
Larry Corbin.
Give me 1 second until I. Got it. Okay, go ahead, Mr. Corbin.
During the November 6, 2018 general election, the Taylor County election official received an absentee ballot in the name of Agnes Corbin. The absentee ballot was rejected because of the signature mismatch. During this interview of Ms. Agnes Corbin, she said that she did not know why her husband signed his name on her oath envelope. On the envelope.
So the question is, did you, for your wife, did you sign her name to the oath envelope?
They're saying it's, I signed my
I
name.
think he signed his name.
To her, to your wife's
Yes, yes, sir.
Oh, did you do that?
But like I told, I don't remember signing my name to. She said she didn't know why I signed my name to her envelope.
Right.
Her oath, it was on the oath envelope. I knew it sounded. It kind of made it sound weird to me. The car for, but it would reject the car for. They said I signed my name to the oath ballot.
So, Mr. Corbin, I think what the allegation is that a ballot was sent to your wife Agnes Corbin. Is Agnes Corbin your wife?
Yes, sir.
Okay. So when she was contacted, because it's her ballot that was being reviewed, the signature on the oath envelope, which is where you swear that the ballot is true and correct, and the person that's submitting it, your wife said she didn't understand why you had signed
Yes.
her oath envelope. And I think the only question we have is, did you sign your wife's oath envelope?
If I did, it was by what I was consumed that it had to be witnessed. You had to have the ballot witnessed before to be returned in.
Okay. So you're not denying that you did that, you just maybe had a misunderstanding about it?
Well, yes, sir.
Mr. Chairman, can I ask the investigator, did he sign his name?
He did, sir. Yes, sir. His name was signed on her envelope.
So in other words, he didn't try to forge her name, he just signed
No.
his own name?
No, sir.
Okay, that's,
Helpful.
okay, I understand. Mr. Chairman, I would add his name to my motion.
All right.
Mr. Corbin, let me
Yes,
ask
sir.
you. I assume that on a signature mismatch, if a ballot's being rejected, they would have sent you a notice that said it was being rejected. Do you remember getting a notice in the mail that said your ballot was going to be rejected and not going to count?
No, sir. I don't even know whether her. Most of the time, I work out of town, and that's what the purpose of the absentee ballot. And after we had, after I got this letter, I know now from my own, I just don't need to get an absentee ballot. I just
So
try to, take
Okay.
the day off or whatever I need to do to just go and vote now.
Okay, so, but you're clear in your mind that you should sign your ballot and she should sign her ballot?
Yeah, well, go and vote. We both of us at the age now we can, like I say, I'm almost 70 years old and I'm still out working, but when it comes down to election now, it's better just go to the poll and do it.
So Ed's got a motion? Ed, you made the motion?
I'm going to clarify.
Okay, thank you, okay.
Okay, so I'm going to just restate, make sure I have all the names.
Let's make sure
So the motion
The
is,
motion is, find technical violation, send a letter of instruction, to people not to please do it again. And I believe the folks that we have listed are Lynn Christian, Katie Whitfield, Nidra Stewart,
no, we have Kanida Nisha Combs.
Laurel, Deborah Black. Elise Moore,
Yes.
And friendly amendment to add Mary Bryant, the very first person who, the technical violation was with regard to an application and not a ballot.
So here are the names I have: Mary Bryant, Lynn Christian, Katie Whitfield, Tanisha Scott, Nadra Scurry, Laurel Corbin and Deborah Block. So the motion is to find technical violations by these people, but to send them a letter advising them that they should not sign on behalf of other people and to follow the law as it respects to applications and ballots and ballot oaths. Okay, and has that been seconded? We need a second, yeah? So it's seconded. Is there any discussion? Right?
I just want to make the comment that this was in 2018. In 2019, the law changed rather substantially so that there is now a cure process. And I want to also commend the incredible investigative work that went into this. There were hundreds. I don't know that nobody can see the investigative files and all of the cases that were investigated and dismissed, which is a testament both to your work and to the work of the counties that they have undertaken over the years and making sure that they are taking their process and their signature review processes very seriously. So I just wanted to point that out, and my thanks to you all.
The other thing I'd like to say is this system works. So if we didn't have the respondents who took the time to come down here and provide the explanations to us that they have, we could not have reached this fair decision. So we appreciate the time and effort. Citizen participation is important in all things. And with that, I'll call for the vote. All those in favor of the motion say aye. Aye. All those opposed, no. The motion passes. So all the respondents that would rather spend time at places other than here, I encourage you that you may leave now if you like.
You don't have to tell her twice.
Well, we're not locking you in. I mean, it's.
Thank you.
The next is case number 2020-80, Fulton County, the 2020 runoff election. Could you brief us on that, please?
We still have other respondents.
Oh, you're right. I'm sorry. So with respect to the other respondents, do I hear a motion?
Time. Beginning with Denise Cobb, and my concern about Ms. Cobb is that she maintains that the only thing she did was sign the application, but did not sign the ballot. But the ballot, if I could have the investigators up here, it's the ballot that was signed improperly. And at this time, I don't believe I have clear enough evidence, clear enough knowledge as to what exactly happened there. And for that reason, I would move that it be referred to the Attorney General, since there is a discrepancy in the testimony.
Is there a second? A referral to the Attorney General doesn't mean that they can't provide more input. Or
They can provide more information. The problem is that the respondent asserts that she simply signed an application, which, I was prepared at that point to go along with simply a letter of instruction. But the investigators found that the problem was with the ballot, not with the application. So there's a discrepancy that.
I think we just voted to send her a letter of instruction.
No, I did not include her name on it for that reason. Is because there is discrepancy. Now, I don't know, it's a discrepancy that may be able to be cleaned up by the Attorney General's office, but we do have two different stories. We have but more specifically, we have the documentary evidence, and then we have her testimony, and they they don't match. For that reason, I would send the matter to Attorney General for further investigation.
Second.
Okay, it's been moved and seconded that we refer Denise Cobb to the Attorney General's office for further investigation and appropriate disposition. And that appropriate disposition, by the way, could be that they recommend to us that we dismiss it. It's just a matter of trying to resolve these discrepancies.
Yes.
Is there a second to the motion? Is there any discussion? It's been moved and seconded with respect to Denise Cobb on 2020-01, that her complaint against her be forwarded to the Attorney General's office. There being no discussion, all those in favor say aye.
Aye.
Those opposed, no. Passes unanimously. Linda Howard?
Let me get, with the investigator, let me ask you about Linda Howard. Did you find any discrepancy between your documentary findings and her and what she said had happened? Did you find any discrepancies?
You know, in talk, Supervisor Archie just left, but yes, I spoke with him and he said that basically what she said and his investigation were totally two different things. And that what he found was what he documented in his interview with her, etc.
Well, this says that she signed her husband's oath envelope by accident. What was the accident?
This is Linda.
You know,
Linda.
I thought we were talking about
No. I'm talking about Linda Howard. I'm going down to the
Howard.
word.
Okay, let's go back. Let me go back.
My point being, I don't see a discrepancy. I just want to get that confirmed before I make a motion.
Yeah, it looks very similar to the previous where she signed her name to her husband's oath envelope.
Okay. With that understanding, Mr. Chairman, I would move for us to take a similar position with finding of a technical violation and sending a letter of instruction to her.
Is there a second?
Second.
It's been moved and seconded that we find a technical violation for Linda Howard in this complaint and that she be sent a letter of instruction. Is there any discussion?
Linda Howard should send Mr. Corbin a letter of appreciation.
I'll leave that up to Ms. Howard's discretion.
I don't have to draft that letter too, do I? All right, there being no further discussion, all those in favor that Linda Howard be found in technical violation but receive a letter of instruction, say aye.
Aye.
All those opposed, no. It passes unanimously. Teresa Davis.
Mr. Chairman, if I can, same question. Did you find any discrepancy? But apparently she says that she signed her husband's name because of his medical disability. I guess two questions there. Number one, did y'all get a chance to talk to the husband? And was the documentary evidence consistent with what she claimed?
I would have to get the file because the investigator actually just walked out. Let me get the file and I can go through the file.
If I might add a comment on some of these, I see a substantive difference when a voter is signing somebody else's name and when they sign their own name on somebody else's line, because there is no intent to make anyone else believe that it's, when you're signing your own name, it's very clear that you're signing your own name. When you're signing somebody else's name, while there may not be an intent to defraud, that is still a fraudulent signature.
Yeah, I think I agree with that, but it's ambiguous whether when they said they signed their husband's name,
Yeah, that's what I'm
whose
looking
name was signed.
Exactly.
That's what I'm looking for.
You know what, the most expedient thing to do potentially is maybe to have the investigator come back, because otherwise I'm gonna have to dig through this, and of course, it's 87 pages and a lot of exhibits.
Okay.
So if we want, can we come back to this? Because he should be on his way back. We're gonna have him come back.
That's fine.
So should we continue this until later this afternoon, the remainder of the case, so that we can keep going? I move that we
Continue this.
continue this, the remainder of these cases until we can get a little bit more information. Either we can, at the end of this afternoon or tomorrow morning, depending on when the investigator is available. Oh, he's coming right back?
I think he thought it was over, and he was heading back to Macon, so.
Because define right back for me. Okay. So right back means as soon as he walks across the street?
Okay, all right.
Well, I'd like to finish this if we can, so if we have to wait a couple of minutes, let's do that. Is he coming back? All right, I'll entertain a motion to defer the rest of these people for the first of the meeting tomorrow. Can somebody make that motion? You did?
For it till tomorrow?
Yes.
I so moved.
Okay. Is there a second to defer the rest of the individuals on this complaint until tomorrow morning?
Second.
Is there any discussion?
One question, does that mean that your investigator will have to drive back up from Macon again? So what about deferring it till the end of today?
Well, tell me why he left. We're in the,
He thought it was done before we were ruling on it. He didn't know that we were going to each individual. So he thought it was-
well, the next time he should ask whether or not we're done with his services. All right, we'll defer these until the end of the meeting. Is there any objection? All right, they're deferred until the end of the meeting. So let's go on to the next. Which is 2080 Fulton County 2020 runoff election, tab 13. Can we have a report on that, please?
Okay, in this case, there were multiple complaints, 29 citizens about Fulton County Board of Elections and Registration. The complaints range from citizens not receiving their absentee ballots, to votes not being counted, and issues brought 2020 general primary, the August as listed, the September 2019-2020 special election, and this ultimately resulted in 12 citizens being unable to vote. One of the citizens was able to vote in person. One citizen ended up voting by provisional ballot. However, election and records indicate that she did not vote in the state election. She's never notified of the reason why her vote was not counted. In addition, Fulton County did not approve her vote as part of the official tabulation, which would be a violation of CBA 21-437 sub D. So during this investigation, there were 14 complaints out of the 29 that were submitted, in which there was no evidence of any election law rule being violated. However, in one instance, a citizen admitted to repeatedly taking pictures of her ballot over the years, and that was not written up as a violation. However, we addressed that with that person who did that and let them know that that is prohibited. That is a violation of the law. So, as I said, there's multiple charges, and I can go down the list and read what we discovered during our investigation. If you would like, on the board.
What's the board's preference on that? Do we need to go through each person and vote on them separately?
Essentially.
No, this is all the same respondent, right?
Yes.
So I don't think we need to go name by name.
It's just counts, multiple counts.
Right.
Yes.
Was there a motion?
Do we want to give the respondent an opportunity to speak to this?
Yes. Does the representative from Fulton County want to speak to these?
Good afternoon, Chair and members of the board. Our staff recently reviewed this case and found the following. I can go paragraph by paragraph or read each person's name if you prefer. For the first paragraph, for those 3 voters, the ballots were mailed on September 19th, 2020, and not returned by the voter. On the second paragraph, for voter Cantor, the ballot was mailed on 9/9 and accepted on 9/21.
Ms. Williams, I'm just having a hard time finding what paragraphs you're referring to on the potential violations. Is that?
I'm looking at, yes, right now I'm on voter Quentin Nixon.
She's in the third group of names on our potential violations.
Each paragraph has a different voter's name.
Page 2. Page 2 of the summary.
Okay, so let's start again. Cheryl Henning, Mark Olson, and Dorothy Bergenon.
Yes, our archives indicate that the ballot was mailed to each of these voters on September 19th and not returned by the voter. On the second paragraph, which is Angela Cantor,
19th.
September 19th.
The special election was 10 days later.
It was mailed on September 19th is what we have in our records.
Sorry.
How long before the election are the ballots supposed to go out? 10 days?
Prior to the passage of SB 202, they had to go out minimum at least 5 days before the election. So the Friday prior to the Tuesday election day. So this was well within the previous legal deadline.
Okay, thank you.
Okay, for Angela Cantor, the ballot was mailed on September 9th and accepted on September 21st. For Mr. Nixon, for the June election, the ballot was mailed on May 17th and not returned. For the August election, the ballot was mailed on July 25th and not returned. For Mr. Robert Boyd, there are 16 electors that have the same name, so we would need more information to review that voter. On paragraph number...
Ms. Williams, let me interrupt you real quick. So on the ones that you've already done, that you say that you mailed out the ballot on a timely fashion within the law, you want us to dismiss those, right? That would be your
Yes.
request?
For our records, it was mailed timely. It was just, we did not receive the ballot back from the voter.
Okay, it'd be very helpful to us, not that you were doing anything wrong, but just to help us out. If you think that you all complied with the law and did what you're supposed to say, just let us know that you don't think there's a violation and you'd like for it to be dismissed, and that'll help us keep score if that's okay.
Okay, yes, sir. May I say that we believe that we complied with all of the voters on this list?
You could probably just shorten it and say,
Okay.
in order to be dismissed or something.
Okay.
Just kind of help us keep up with it.
Okay, yes, will do. Okay, so for Mr. Boyd, there are 16 electors with the same name. If you can provide more information, we could do more research on that voter, but we would like that to be dismissed. For Mr. Russell, we have no record of an absentee ballot request, so we would also like that to be dismissed. For Mr. Alphison, there is also no record of absentee ballot request, so we would also like that to be dismissed. For Vivian, and forgive me for the last name, Capernew, there is no voter under that registered name in our records. We would also like that to be dismissed. For the next two voters, Rachel Quas-Barth and Mr. Travis, the Jarvis system does not indicate what party those persons are registered for, so we're not able to confirm what ballot was mailed. It's not currently in the Jarvis system. And now I'm on paragraph 10, Mrs. Margaret Sullen. The next three paragraphs refer to that same voter, and per our records, the ballot was issued to her on August 7th. It was canceled, and our records show that she voted on election day. And we'd also like that to be dismissed. And that concludes the voters listed on this report.
This. Who gave you the names claiming that they hadn't voted when the records are so contrary to what the claim is?
So one of the issues is that in those 17 instances, we didn't receive any information. And from the investigation, it looks like there was nothing on ElectionNet to verify what the Fulton County representatives are saying. So in many cases, there was a subpoena sent out requesting information on all these individuals, and that information wasn't provided to our investigators.
Subpoena went to Fulton County?
Yes, sir.
Why did that happen?
This happened in 2020, so I have no record of that, but if we can now provide supporting documents for everything that I read off today, we can do so.
Well, but what I hear is that you were subpoenaed to provide the documents about these voters, and now all of a sudden you have the information.
I was not subpoenaed. This is our previous director.
Well, I'm not
Yeah,
saying
so-
you, I'm just you in the broad sense, the institution.
I cannot confirm or deny that subpoena was submitted, but we do have supporting documents if needed at this time.
Mr. Chairman, I move to continue, and ask the Fulton County, because, Fulton County had indicated they really just provided us with documentation.
I would move to continue so that they can provide that so that that they can provide that documentation to the investigator so that, if correct, we can deal with this expeditiously, but let's get the documentation to the investigators. So I move to continue.
I'd amend that by saying that I'll continue it, but I will give you until the 1st of July to have somebody from your office come down and meet with the investigators and give them the information that you claim you now have.
Okay, we will do that. Thank you.
Thank you. With that friendly amendment from the chairman.
Second.
It's been moved and seconded that we continue these to the next, this entire complaint was at SB 2020-80 to the next meeting, but that a representative from Fulton County meet with and provide to the investigators in this matter all of the underlying information that they claim disputes the recommendations and found violations in the report. Is there any discussion?
Question, are absentee ballot outer envelopes scanned before they're mailed?
Did you say scanned?
Correct.
We have believe we have a image of them before they're sent out.
I'm sorry, a what?
We have a record of them. There's a log that we keep as when they're mailed out.
Okay. Is USPS tracking utilized for absentee ballots?
No, we mail them through the postal mail. We do not put them through.
I'm sorry?
We made them, you said UPS?
USPS tracking?
We do not currently have a system that tracks that, but we do, like I said, we do have a log of when it's mailed and stamped.
It would be great if all the ballots were scanned in the office before they're mailed, and also USPS tracking was utilized to follow outgoing ballots, absentee ballots.
Well, that's not part of the motion, and that might be a good suggestion. If USPS tracking is as good for the county as it is for my home, I'm not sure it's all that reliable. But you might want to consider whether or not that's worth asking the Postal Service to provide that service for you. All right. Any further discussion? All those in favor of the motion for continuance and for the production of information and a person to explain the information to the investigators by July 1st, say aye.
Aye.
All those opposed, no. That passes, and this is deferred. I will say this is really frustrating that we spend all this time going through all this and find out that there's information that was never provided. And now we have to defer this. It'll take time, and we came here ready, thinking that we had all the information that had been requested by the investigators, and it's troubling that it hadn't been. All right, the next is case number 2022-01, Screven County, problems at the polls. Can we have a report on that, please?
Yes. November 18th, 2020, investigations received complaints from the following electors concerning the November 3rd, 2020 general election. Caitlin Bell alleged that her and her husband, Leon Yates, appeared to vote at the Coopersville Fire Station precinct, and the poll pad machine indicated both had already voted. The staff allowed them to complete provisional ballots, and they both forgot to sign before leaving the precinct. Bell and Yates later returned to the precinct to sign, and they discovered that his ballot was signed by someone other than him. The voter crossed out the forged signature on the ballot and signed next to it. The provisional ballot was accepted and tabulated with election results. Thomas Ward appeared to vote at the Bay Branch precinct, and the machine indicated that he had already voted. He was issued a provisional ballot and later tabulated with election results. Natalie Starling alleged that while at the Hunters Community House precinct, she, along with several other voters, were informed that they had already voted when they had not voted in the election. She referenced Charles Hendricks, Laura Hendricks, Chris Tillman, Larry Rivers, Betty Lee, Tanya Burrows, and Benny Weathers and Michael Taylor in her complaint affidavit. The investigator met with Dorothy Glisson at Screven County Registrar concerning the allegations contained in the complaints. Ms. Glisson assisted the investigator by providing copies of provisional ballots for the following electors referenced in the complaints as having already voted: Ms. Starling, Ms. Bell, Mr. Yates, Mr. Matthew Ward, Mr. Hendricks, Ms. Hendricks, Mr. Rivers, Ms. Lee, Mr. Tillman, and Ms. Burrows all had provisional ballots that were accepted. All provisional ballots referenced above were accepted and tabulated with the November 3rd, 2020 election results. ElectionNet verification determined that electors Benny Weathers and Michael Taylor did vote in person. Investigator spoke with Caitlin Bell concerning her and her husband and their voting experience. She said that she and her husband were given voter access cards, and when they scanned them, a message populated on the machine stated that they had already voted. She mentioned that her and her husband had to vote absentee, though she meant a provisional ballot. And she thought everything was fine until she was contacted a few days later informing her that she needed to sign the ballot. When she returned to the office to sign the ballot, Leon discovered someone had forged his signature, so he crossed it out and then he signed it. The findings of this case were that Leon Yates' provisional ballot was signed by someone other than the elector. Poll workers Marilyn Harvey, Joyce Smart, and Arlingo Jackson neglected to ensure that Mr. Yates signed his ballot and denied having signed the ballot themselves. Ms. Jackson admitted completing the top portion of the provisional ballot, but denied having signed Leon Yates' name. There were 3 poll workers assigned to the precinct in question, and consequently all of them denied or could not recall having signed the provisional ballot in question. They did not ensure that Mr. Yates signed the provisional ballot, and the individual responsible for signing his name could not be determined. Therefore, the county election staff and the Coopersville precinct poll manager will be cited for the violation. The potential violations were for Screven County Board of Elections and Registration, Ella Rhodes, election supervisor, Marilyn Harvey, Coopersville precinct poll manager, for violation of OCGA 21-241B provisional ballots. When Leon Yates was allowed to vote a provisional ballot and staff did not ensure the voter certificate was signed by Mr. Yates, but ultimately by an unknown individual.
One question I have is there's this listing of the people who had their provisional ballots accepted begins with the statement that the investigation indicated several voters populated in the system as having already voted and consequently voted provisional ballots. Did you mean to say as having not already voted?
Yes, it was saying that they had voted and they hadn't voted.
So the system showed that they had voted?
Yes, there was a memorandum done where it says, it was discovered during the 2020 general election that poll officials were prematurely removing the voter access cards from the poll pad before the poll pad processed the voter's information. As a result, the access card was reading the previous voter's information. So they hadn't voted, but the card was saying that they had voted.
Well, whose fault is that? I mean, it seems a flawed system. If somebody goes there to vote, they vote, but their vote's not, but they're not recorded in the records as having voted. How could that happen?
Can I ask a clarifying question? So it is the voter access cards were not properly coded. So in ENET, it was coming up properly, but because they were pulling out the voter access cards before they finished programming, when they took that to the BMD, the BMD said you've already cast a ballot on that card. Is that how
Yes,
My understanding?
the equipment was working properly, so the errors on the poll clerk, so they were prematurely removing the access card before it was fully processed. So when they went to the BMD unit to vote, the card was reading the previous voter because it had not properly uploaded the new voter's information. So basically, that was a problem that was happening statewide. So Michael Barnes had advised that information had went out to the election directors of each county, all 159 counties, making them aware of that. I think Blake might be able to give further information.
Just one point of clarity that I want to provide is the only information that's stored on that voter access card is the information to pull up the ballot. So it doesn't identify a voter or anything like that. But if it's not encoded, and the previous voter who had it marked their ballot on the BMD, and then it doesn't get encoded again, and it gets put back in the ballot marking device, then it's not going to pull up a second ballot because it was never properly encoded again. So I just wanted to make that point.
So to be clear, this is a poll worker error because they were simply pulling the cards out prematurely before they were properly programmed. Is that a correct understanding of what happened?
Correct. So the poll book would check the voter in, but if the card was pulled out too early, then the card wouldn't get encoded.
What does it mean to be pulled out too early? How does the poll worker know that they've pulled it out too early or shouldn't pull it out?
Well, so the poll pad, when the voter gets fully checked in and the card gets put in and gets encoded, there will be a screen or a check mark and actually a little sound that gets made that just says that the card has been encoded and everything's been complete essentially. The card can be pulled out and handed to the voter at that point. So, I mean, if you're, processing hundreds of voters in a day, there could be a time when you're doing it just out of habit, you pull the card too early.
If I could make an analogy, is it like when you're using a credit card and you pull it out before the terminal has actually processed it and it says not processed and you have to start over again?
That's a good analogy.
Yep.
So it's the poll worker that when they get that error message, doesn't do what they're supposed to do, which is to call a person back and say, look, I got to do this again.
Essentially, yes, the poll worker should have left the card in longer. So, yes.
Does the poll worker get an error message saying not encoded?
I do not believe in that instance at the poll pad.
No.
Okay, no. Thank you, Joseph.
Yeah, I've heard.
So what would...
I saw the hat going up and down, so I knew it was...
What would happen is then when the voter access card gets put in the ballot marking device, then it would show a message saying that there's not a ballot to be pulled up. It would say card already voted or something to that effect.
So the voter would also get an error message of sorts?
Yes, when they take that card and insert it into the ballot marking device. And that's when a poll worker would get notified and they would start to troubleshoot the situation.
And would the proper troubleshoot be to go back and redo the card, or is the proper troubleshoot to give them a provisional ballot?
If the poll workers know, okay, this person has not actually inserted a ballot into the scanner, they've not actually voted, then they could reissue the card properly this time, and then the voter could vote normally at the ballot marking device.
But the voter that gets this unloaded card and puts it into the ballot marking device, does the ballot come up? And would the voter know that there's a problem?
Yes. If they get a card that has not been properly encoded again, then it would say card already voted, because essentially once you use a voter access card and you print your ballot, without encoding that card again, you cannot bring up another ballot.
Right. So that voter says, well, look, I can't vote. How could they have voted? Well, how could they have done, how could they have done anything? How could they have gotten a ballot?
So prior to the mass notification going out to the county directors, they were voting by provisional ballot.
No, that's not my question. My question is this system where somebody has a card that's not encoded and puts it into the ballot marking device, he sees the screen, and it says, card already voted.
Correct.
So are you saying voters said, oh, I must have voted even though I didn't do anything, and then they leave?
No, the voter complained to the poll manager. The poll manager allowed that voter to vote by provisional ballot. Now, the second part is when notification went out to the counties then knew, let's re-encode the card so that they can vote.
How many instances across the state did that happen?
I don't know if the total number of those instances were actually captured, but we do know that notification did go out by the former elections director notifying the counties of the issue. And I don't think we've had any issues since then after the notification went out.
Right, so ultimately, the only violation here is this one person where somebody unknown signed somebody else's name. Correct?
Yes.
I have a couple other questions. Were all of these provisional ballots at the same precinct and on the same day, or was this scattered over the course of a couple of days?
They were not at the same location. They were a couple different places for these complaints. They were at Hunter's Community, Bay Branch, and Coopersville Fire Station.
Were there more than 3 poll workers at any of the locations, or did all of these polling places have only 3 poll workers at each site?
I'm not sure about the other, the Coopersville had the 3. I'm not sure about the other ones had a minimum of 3.
And this is not a violation, it's a best practices question, because there are so many moving parts that sometimes I can see where if you have enough poll workers and enough eyes on the polls and the voters, you can see that in fact this voter did not cast a ballot. We can reprogram a card versus not knowing and then being forced to go the provisional ballot route. So this is as much a learning opportunity and best practices question as a violation question.
Looks like most of the people that he interviewed are no longer working there, but he interviewed everybody at the precincts. He didn't number them, how many were at each one, though.
That's fine, thank you.
Does this process still work the same way today?
With the cards?
Does this problem exist today? I mean, even though you sent out a notice telling them how to do it correctly, if somebody pulls it out too late, will the voter get the same message on the ballot marking device? And do they
still have them?
Do they have to file a provisional ballot, or do they have to go back now and get a new card? Or
Is the difference now that they know about it, so that they recode it, and so they don't, rather than default to a provisional ballot, they just recode it on the spot now?
Yes, sir. That's a lot of it, yes, sir. As that, if that occurs, they know to recode the card. And so we don't hear about it as much at the state level because counties know if it happens, how to respond to it.
And so these people were allowed to vote by provisional ballot, and all except for one case, maybe, their votes were counted. They were allowed to vote, and the provisional balloting system that was innovative at its time worked. And in the old days, you just got, it's too bad you got sent home and you didn't vote. So the provisional balloting system worked, but there's a different cure now, so you don't have to resort to the provisional ballot, right?
All the votes counted. 2 of the people did vote in person, though.
Okay.
That woman's affidavit had, so they did vote.
Are there any more questions from board members? And if not, is there a motion?
So we've got just one count of forging of voters to a provisional ballot or some form that they forgot to get him to sign it when he was there, and so they forged it, and then he came back and they went, oops, he's here. We don't need the forgery anymore. Okay, I got it. So I move.
He crossed out the name.
And then he signed.
Then he signed.
Okay. All right, so I'm convinced that's a violation and should be sent to the Attorney General's office, so I make a motion that one count be sent to the Attorney General's office.
Any second? It's been moved and seconded that SCB 2020-201 be sent to the Attorney General's office. Is there any discussion? There being none, all in favor of the motion vote aye. Aye. Opposed, no. The motion carries. SB 2020-271 statewide buying contest. Do we have a report on this, please?
Okay. This case involves 2 allegations.
Hold on for 1 second. So Mr. Lindsay recuses on this matter because of a conflict and will not be participating in the consideration of it or the vote. Go ahead.
Okay. This case involves a contest, an online contest. Actually, there's 2 allegations here. So the first involves an online contest, and the second involves what we determined later was an employment offer or opportunity. So, in looking at this case, this came to the Secretary of State's attention in December of 2020, and it involved the runoff election. And in looking at this case, there was an advertisement, a giveaway contest from a website indicating that someone could enter for a chance to win a Tesla if they requested a mail-in ballot or checked their voter registration status and the contestant pledged to vote. Now, there was a disclaimer at the bottom of the page stating voting by mail, or completing a mail-in ballot application are not required for entry. And additional online and digital magazine articles were also located that discussed the giveaway, as well as the partnership between an organization by the name of Headcount and the music artist 2 Chainz. So our investigator reached out, spoke with the executive director of Headcount, Andy Bernstein, and in summary, he reiterated that to be entered into the contest, the person had to request an absentee ballot through the Headcount portal, complete a check your status voter registration verification entry form, or by mailing an entry card to them which contains the contestant's information. They confirmed that a winner was selected after compiling all the contestants onto a spreadsheet and then using a random number generator program to obtain a random number. Once this number was generated, the corresponding row number on the spreadsheet was declared the winner. The winner was notified on December 22nd, 2020, and the prize was redeemed by the winner on January 20th, 2021. So that's the first part of the complaint. The second part, there was an advertisement regarding a community mobilizer positions on the Jon Ossoff campaign website. electjohn.com. During this time, he was involved in the U.S. Senate runoff election, which was held January 5th, 2021. The advertisement stated, "Now hiring, apply now." And John Ossoff for U.S. Senate is looking to add people to our team who are willing and able to talk to their own friends, family, and community members about this runoff election. Our investigator was unable to locate any additional information, postings, or advertisement which offered gifts or payments for voting, registering to vote, or voting for a particular candidate. Nothing in the wording appeared to be directed towards the voter themselves, rather to a potential employee or canvasser campaigner acting on behalf of the campaign to solicit votes. So ultimately, we did find evidence in the first part of the allegation based on the giving of the gift, obviously, the Tesla that was ultimately won by an individual. The second part we did not find because there was no offer for those things. It was more of an employment to be a canvasser or a campaigner for a particular campaign.
Your Honor, whenever the time is appropriate, I'd be happy to make a comment.
It's your turn.
Thank you, Your Honor, members of the board. I represent headcount. I don't represent the second part where the allegation was determined to be unsubstantiated concerning Senator Ossoff. Headcount's been around for over 19 years. This is the first time there ever was a complaint concerning headcount. They're involved in civics initiatives. There were 3 ways to enter the contest. And as stated, way 1 was to check your voter registration status. Way 2 was to request a mail-in ballot application. And number 3 was to mail in an entry postcard. All 3 of those are fully compliant with OCGA 21-2-570. Crucially, registering to vote was not a method of entry. Whether someone voted or was registered to vote had no bearing on their chances of winning. The rules themselves specifically stated in numerous places, voting by mail, or completing an absentee ballot application are not required for entry. Once again, totally consistent with the code section. There was, however, an ancillary material as referenced that is a mistake that should have never gone out, that headcount feels terrible about, that was not consistent with the rules of entry, and that was not pertinent to the rules of entry. Headcount thought they were fully complying in the rush of the runoff for the Senate race. Quite frankly, as I mentioned, that was an error. It shouldn't have happened. Once again, they've never had a prior complaint with the state of Georgia. They acknowledged that that shouldn't have happened, and they would welcome a letter from this board of instruction and promise that this type of thing would never happen again. Thank you, Your Honor.
All right, is there a motion?
I move that we issue a letter of instruction as requested.
Second.
It's been moved and seconded that a violation be found and that there be issued a letter of instruction. Is there any discussion? Well, I don't agree with that disposition. If I am to accept what is said in this report, it said that the mail-in balloter stated that you could enter for a chance to win a car if you requested a mail-in ballot or checked your voter registration and the contestant pledged to vote. Now, at some point, somebody won a car. And so by pledging the voter to do one of these 2 things, they in fact got an automobile in return for conduct, which I think is prohibited by the statute. And to say that to entice people to engage in the process. I mean, we're not talking about a basket of fruit. We're talking about an expensive automobile, which ought to motivate a lot of people to do what is requested and to make the pledge that you're going to vote. And I think a letter of instruction with a company that claims that they do this all the time and didn't do it in this instance ought to be held accountable for that. Or at least I ought to let the Attorney General's office look at it carefully and study the statute carefully to decide what the appropriate disposition is that they would recommend to us. And I just think a letter of instruction is not enough.
May I please respond, Your Honor?
Yes?
There's never been an allegation that they've ever done this before. The only evidence before the board is that in the rush of the runoff, they made a mistake. Also, I don't say this with anything other than the factual statement. When you read the statute, this statute is not well worded, like many statutes. And it literally says giving or receiving money or gifts for the purpose of registering as a voter, voting, or voting for a particular candidate. Pledge, frankly, isn't even a part of the statute. One can easily make an argument that it should be a part of the statute, but it is not. This company, this nonprofit is coming forward acknowledging a mistake was made in an advertisement. There is no evidence that the rules of the contest violated Georgia law. The only evidence is that an advertisement used inappropriate language. And I think there's a distinction between a contest that overtly violates the law and an advertisement that accompanied a contest that was inconsistent. And that's the only thing I would raise to the members of the board, and I appreciate your assistance.
Well, I understand the distinction that you're trying to make, but we generally do letters of instructions for fairly innocuous events. This is not. I mean, this was an attempt to incite people or to encourage people in return for something valuable to engage the system. And I'm just not comfortable making that decision based upon, and to resolve this by me writing a letter saying, don't do this again, thank you for reporting yourself, in this particular offer. And what I'm saying is I think it ought to be sent to the Attorney General's office for their evaluation and to let them do whatever additional investigation they want, and then to come back to us to say what they think is the appropriate disposition. And if they say that it's a letter of instruction, then we can decide to do that. Or if they say it's a consent order that they don't do it again, we could do that. I just don't know what their advice is going to be. So that's my input. My board members are perfectly capable of voting differently than me. So my amendment, I would make an amendment to the motion, which is that it be referred to the Attorney General's office and that we delete the language about and to issue a letter of instruction. So is there any discussion on the amendment?
Your Honor, I apologize. Your mic wasn't clear.
Sorry.
I honestly didn't hear your amendment.
No, you and I have the same problem. Our voice is becoming weaker and weaker. That's all I need. So my amendment is, the motion on the floor is to refer to the attorney to find a violation and to send a letter of instruction. I'm making an amendment that we find a violation and that we refer to the Attorney General's office for further investigation and for whatever they decide is the appropriate disposition, which could be a variety of different things. I just don't know what they would recommend to the board or whether they would take it to a hearing. So the amendment is to delete after we find a violation, is to delete the language and to send a letter of instruction, and to substitute for that to refer to the Attorney General's office. So the amendment is to refer to the Attorney General's office, and now the amendment is open to discussion. Great, so we'll vote on the amendment to begin with, which is to substitute refer to the Attorney General's office for a letter of instruction. All those in favor say aye. Aye. Opposed? So it's 2-2 because Mr. Lindsay is not here. The motion does not carry by a majority, so now we'll go to the main motion, which is to refer, to find a violation and to refer a letter, and to send a letter of instruction. Is there any further discussion on the main motion? All right, all those in favor say aye. Opposed, no. No. So it doesn't carry. So what I would suggest is that we defer this when we I guess we'll never have a fall contingent. So I guess that motion fails. I don't know. What do we do now?
I'll move to table. I'll move to table this case.
And what do you mean by that under Robert's rules?
It goes on the table until someone makes a motion to pull it off the table.
I find that exceedingly difficult for the respondent because that just leaves it hanging there. So perhaps we should get into a little bit further discussion and maybe we can try to figure out if we can move this. Because I think for the sake of the Attorney General's office, the investigators and the respondent, it would be in everybody's interest to try to get some kind of resolution here. If I can ask a clarifying question, Mr. Olens, was it very clear in all of, aside from the one advertisement, was it very clear that there was no action related to voting required in order to qualify to win this prize?
Absolutely. It was listed in several places. When you look at the actual rules, which is about a 4-page document, approximately 3 times that's expressly stated.
And how many? Where was this advertised? Was this in mainly social media, online?
Online.
Okay.
And you know, my client would be agreeable. I don't know if it would make a difference to the, you know, as far as this 2-2, they'd agree to meet with SEB and have an instruction program, whether it's Zoom, et cetera. They're not looking to do anything other than follow the law. And we're simply acknowledging that one page was in error. We're not looking to be anything other than fully compliant with Georgia law.
You may not know the answer to this question, but how did the page that was sent in error get past? Is there a legal department or somebody serving, or is that you, or?
No, it wasn't me, Mr. Rashford. I think candidly, in the haste of the runoff, a mess up arose. It's literally that simple. Someone made a mistake. It wasn't done by the executive director. It wasn't done by the number 2. But we don't deny that the mistake was made.
All right, so, and your desire, your intention, y'all's attitude toward this is that we can't believe this happened and we don't think it'll happen again.
No, our statement to the board is it should have never happened. We fully seek to comply with the law. We acknowledge a mistake was made on that one page, and we want to make sure it never happens again.
And so if this were to get referred to the Attorney General's office, y'all would be of a mind, and I don't want to bind you to this or get into attorney advice or anything, but y'all would be of a mind that a cease and desist would be an agreeable outcome from y'all's position.
I want to see the language in a cease and desist, Mr. Mashburn. I've noticed, you know, there's numerous types of cease and desist. They're no longer doing this.
Yeah.
This happened literally once. Unfortunately, this is the once. You know, this dates several years back. It hasn't again, won't happen again. And they're just coming before the board, frankly. They're not trying to play games with the board. They're not trying to be ambiguous with the board. They're acknowledging that one time was one too many and that they will make sure it doesn't happen again.
Well, I think the question was, would they object to entering into an acceptable cease and desist?
Theoretically, they would not object. It's frankly a function of what is the exact language that the Attorney General's office would proffer.
So if we refer it to the Attorney General with a statement from the board that the board is leaning toward a cease and desist as a favorable outcome, are we overstepping our bounds into their authority to negotiate the case?
I have seen similar recommendations, I believe, before, where the board has thoughts on a case, but it can only be resolved under the consent order that went to the mediation's office.
I'm happy to make that, to agree to that recommendation. And I'm happy, you'll be involved in the discussion about what the cease and desist is, and I think that that's the practice of the Attorney General's office, as you probably know.
Yes, sir.
But if that's the case, if we refer it with the recommendation that it be resolved by a cease and desist order, I would entertain that motion.
Second.
So the motion is to refer this matter to the Attorney General's office with a recommendation that they enter into, in discussions with counsel for the respondent, a cease and desist order. So that's the motion. Is there any further discussion?
I would be interested to know the Attorney General's investigation, look into the markets that were
And Dr. Johnston, I heard your comments earlier this morning in that regard. There were no limitations, none at all.
All right, any further discussion? There's a motion to refer this to the Attorney General's office with a found violation, but with a recommendation that it be resolved in a cease and desist order. All those in favor say aye. Aye. Opposed, no. The motion passes unanimously. I think
There's also allegation 2.
an allegation 2, is there a motion with respect to allegation 2 that was found to be unsubstantiated?
I would dismiss allegation 2.
Is there a second? Any discussion? Okay, it's been,
Discussion. Yeah, to me, this just sounds like paid canvassing, and Republicans do it too. And in fact, a friend of mine's daughter does it for the Republicans, and he would be very mad if I took away her job. So, yeah, I think this is just paid canvassing.
which is not why we're taking this vote, to protect a young woman's job.
Thank you.
All those in favor of the motion to dismiss, say aye.
Aye.
Opposed, no. Then it passes unanimously. Thank you very much. Thank you for your presentation. We appreciate it.
Thank you.
All right, we're now on 2021-141 Fulton County illegal shredding. Can we have a report on that?
Yes.
Sarah?
The Secretary of State office opened an investigation after receiving a report which alleged that 2 Fulton County election staff members improperly shredded voter registration applications, which they claim were illegible or otherwise unable to be processed, a potential violation of OCGA 21-2585, removal, destruction, or alteration of documents, and OCGA 21-236, periods of retention of applications. The former election director, Richard Barron, advised 2 of his former employees, Ms. Little and Ms. Parker, were accused of illegally shredding voter applications. Richard stated that Ms. Dixon overheard Little and Parker talking to each other about shredding a registration applications that they couldn't read. The investigator spoke to Ms. Dixon, and she advised that they were sitting at her desk and heard the shredder running. Dixon stated they weren't supposed to be shredding anything, so she approached Little and asked her what she was doing. Little advised the applications were old. Dixon stated that Parker was handing the applications to Little to be shredded this time. According to another witness, Ms. Frazier, she heard Little state that she was going to shred voter registration applications that she could not read. Frazier heard the shredding machine turn on and saw Little shred documents that appeared to be voter registration applications. Frazier also heard Parker as little what she could with applications that what she should do with applications she could not read, and Little responded with, "Shred them." Parker asked Little if she was sure, and Little laughed and stated that she had just shredded some and that people needed to learn how to write. Frazier advised that Little and Parker were shredding the applications and that Parker hid the applications behind the shredder and turned off the shredder because she thought the supervisor was walking into the room. Frazier said at that time she could see that there were shredding registration applications. The investigator emailed Patrick Eskridge to know how it was determined that Little and Parker shredded registration applications based on shred evidence collected. Mr. Eskridge stated that when the bag of shredded paper was retrieved, he looked inside and immediately recognized the shredded paper as voter registration applications based on their appearance. The investigator obtained from Fulton County Elections Office Deputy Director Patrick Eskridge the standard operating procedure when registration clerks encounter an application which is either not legible or unable to be processed. And in summary, the clerk is supposed to conduct additional research to attempt to identify the registrant. For new voters, the clerk should have entered as much information into ElectionNet as possible and checked the missing box if any information was missing. If a registered voter's street is not found, the voter was to be sent a letter and the application retained until the deadline on the letter expired. The findings on this case are the allegation that 2 Fulton County election registration clerks improperly shredded voter registration applications, which the respondents claim were not legible or otherwise unable to be processed, is substantiated. The actions of the 2 respondents were witnessed by 2 other election office clerks. The bag of shredded material was collected and secured by election supervisors and turned over to the Fulton County DA's office. Based on their appearance and texture, some of the contents of the bag were immediately identified by election supervisors as voter registration applications. Potential violations were the OCGA 21-585 and OCGA 21-236 for Rhonda Parker and Shimon Little.
Thank you. Are there any questions for the investigator? Is the respondent, or either of the respondents here?
I can make a statement for Fulton County. In regards to that, yes, there were 2 workers that reported that they saw their co-workers commit this act. Our department reported it to the DA. Our department reported it to the SOS. We also made a public statement for any voters at that time who had submitted applications, if they have not received verification, to make sure that, their application was processed, to make sure that this incident, and also those employees were terminated immediately. And to make sure that this does not reoccur, we removed the shredder from the work area and repurposed one of our absentee drop boxes as a lock place to place the items that need to be shredded at a later date.
Well, you're not
And I do ask the case to be dismissed if possible.
Well, first, you're not a respondent. Only the 2 individuals are respondents. So is there a motion?
I motion that we bind these 2 respondents over to the Attorney General's office for further disposition.
It's been moved and seconded that we refer this to the Attorney General's office for further investigation. And I think the Attorney General has the option, assuming that there's criminal liability, that they could refer this to the district attorney. So that's the motion. Is there any further discussion?
Just in brief, I wanted to thank I remember when this happened, and we all learned about it as it happened because the county responded very quickly. And I just want to commend you for doing that, for being very transparent with the response, and also my question was going to be, have you moved the shredder? And you anticipated that, and you did, so, thank you.
I mean, it can't go to you, but you could tell us. So, I've just been told that if there's a referral to the district attorney's office, it has to be made by us, and that what the board has done in the past is voted to refer it to the, either, well, to the, just to the Attorney General's office and to the district attorney. So what I would move, since we could not refer it to the Attorney General's office for further referral to the district attorney, I would make a second motion that it also be referred to the district attorney for Fulton County, or any other appropriate district attorney. Is there a second to that? That in fact it has already been referred to the district attorney's office, so that we don't have to make that recommendation. In fact, there's some question about they had custody of the shredded ballots or the applications, and that they were investigating these two women. So it's not necessary to do that, so we can move on to the next complaint. And thank you very much, Beth, for telling you that.
Are we going to refer this to the Attorney General's office?
We've already voted on it. Yeah. Hey, you forgot something. All right, the next case is 2022-088 Gwinnett County out-of-state voter.
Your Honor? Yeah.
I'm sorry, 2022-10 Cobb County
Okay.
residency.
Okay, this case was brought to the attention of the Secretary of State's office February 2nd, 2022, after we received a letter alleging that a Miss Samara Tushban was a resident of Barrington, Illinois, when she requested an absentee ballot from Cobb County and voted in the November 3rd, 2020 general election. This would be a potential violation of OCGA 21-217, Rules for Determining Residency, in addition to Statute 21-216. So our investigator conducted a search of the Cobb County Tax Assessor's Office on Mrs. Tushban's listed address in Marietta. It was the same address listed on her voter registration. It showed that the home was owned from September 12th, 2012 until an ownership change in June 29th, 2019. He spoke with the current owners, who stated the house was vacant approximately 6 months before they purchased it, and they had never met the previous owners. The investigator was later able to speak with Mrs. Tushban, who indicated that during the 2020 election, she was living in Chicago and had been living there since 2018. She stated that she did not have property or residence in Georgia since her home was sold there in 2019. When asked why she voted in Georgia while a resident of Illinois, She indicated that she was still registered there and that she had not registered to vote anywhere else. She was not definitive on returning to Georgia at some point in the future. She has since then registered to vote in Illinois in 2023. She also obtained the Illinois driver's license on February 23rd, 2023. So when she requested an absentee ballot for the state of Georgia, she was living in Illinois, is basically what we found out through our investigation. And the two violations that I noted were our recommended findings for this case.
All right, any questions from the investigation? Is the respondent, Ms. Tushan, here, or her representative? All right, is there a motion?
I find that there's sufficient evidence to believe a violation has occurred and move to refer it to the Attorney General.
Is there a second?
Second.
All right, it's been moved and seconded that case number 2022-10 be referred to that a violation be found and that it be referred to the Attorney General's office. Is there any further discussion? There being none, all those in favor of the motion say aye. Aye. All those opposed, no. Then it is referred and the motion passes unanimously. All right, now we're to 2022-88 Gwinnett County out-of-state voter.
On 5/21/22, we received a complaint via the online reporting system that two voters, Kyler Knutson and Kevin Knutson, live out of state but voted in Gwinnett County, Georgia during the early voting for the general primary election, May 24th, 2022. On 5/25/22, Kyler Knutson returned the investigator's call and advised he currently lives in Alabama. He advised he used the Sugar Hill, Georgia address and is the only permanent address he ever had. He advised he went to college in Alabama and graduated in 2019. He advised he was unsure about staying in Alabama until recently, about a week ago, before 5/25/22. He advised he recently decided to stay in Alabama and is closing on a house. And he will become an official Alabama citizen after the closing of the house is complete. Through research, the investigator learned Kyler has an Alabama insurance license. She spoke to Ms. Moore of the Alabama Department of Insurance, and she confirmed that Kyler has an Alabama insurance license. She advised when Kyler applied for the license, he applied as an Alabama resident and listed Alabama as his home state. She advised Alabama does not offer a resident or non-resident option when applying for an insurance license because it is not a requirement to live in Alabama to obtain an Alabama insurance license. She also confirmed that he would not be able to sell insurance in Georgia with his Alabama insurance license. Kevin Knutson called and advised that the Sugar Hill, Georgia was still his permanent address. He advised he left for college and graduated in 2020. He advised he currently works a remote job for Cigna and he is still uncertain as to where he will end up permanently. He advised he goes between Georgia, Tennessee, and Arizona. He advised he never voted in any other election outside of Georgia, and that has been confirmed by the General Counsel for the Arizona Secretary of State. Through research, the investigator learned that Kevin has an Arizona insurance license. She called Arizona Department of Insurance and the financial institutions to inquire about an Arizona insurance license. It was confirmed that Kevin has that Arizona license. It was advised that Arizona has a resident and a non-resident option for insurance licensing, and in order to obtain a resident Arizona insurance license, a person must be a resident of Arizona. It was confirmed that Kevin applied for the Arizona insurance license as a resident. It was confirmed that with an Arizona insurance license, Kevin would not be able to sell insurance in Georgia. On June 6th of 2022, Steve Knutson returned the investigator's call. He advised he had been away on vacation. He confirmed that he lived at the Sugar Hill, Georgia address. When she asked him who lived at his residence, he confirmed his wife, his parents, his oldest son, son's wife, and child. He advised that Kyler and Kevin have kept that address as their primary address because they are currently working on their first careers out of college. The allegation that Kyler and Kevin reside outside of Georgia were substantiated. It was confirmed they both voted in the general primary election, May 24th, 2022. Therefore, they were not qualified electors in the state of Georgia and were not eligible to vote in the state of Georgia. It was determined that Kyler Knutson and Kevin Knutson were in violation of OCGA 21-2571.
Are there any questions for the investigator? Are Kyler Knutson or Kevin Knutson here to respond? They are not. Is there a motion?
I believe there's sufficient evidence to show that a violation has occurred and move to refer it to the Attorney General's office.
It's been moved and seconded that complaint case number 2022-88 be referred to the Attorney General's office. Is there any further discussion? There being none, all those in favor of the motion say aye. All those opposed, no. The motion passes unanimously. Next is case number 2022-216. Can we please get investigators' report on this matter?
The Secretary of State's office initiated this investigation after it received a complaint alleging that the City of Ranger has not sent in any election results, a potential violation of Official Code OCGA 21-277. On September 20th, 2022, the Georgia Secretary of State received a complaint regarding no municipal election results had been submitted from the City of Ranger since 2007. Chad Stamey, City of Ranger mayor, stated that he was appointed mayor in 2017 due to the lack of citizens attending and participating in city meetings. Mr. Stamey stated that the city has approximately 100 residents and hardly any of the residents come to the city meetings or participate in city business. He also stated that when he was appointed to mayor, he had been serving as a city councilman since approximately 2014 or 2015. He stated that the city has not held an election during his involvement with the city. Therefore, there would not have been an election results to forward to the state. Investigators spoke with Shay Hicks, Gordon County election supervisor. Ms. Hicks stated that the city no longer contracted with Gordon County to supervise or operate the municipal election since 2007. The last election Gordon County had for the City of Ranger candidates on the ballot was the general election in November of 2005. For this election, it included the mayor and city council posts 3 and 4. Ms. Hicks stated that the reason the City of Ranger broke away from the contract was due to financial hardship. Ms. Hicks confirmed that there are 64 registered voters inside the city limits of Ranger at present time. Ms. Hicks had no further knowledge of any election process taking place in the City of Ranger.
Any questions for the investigator? Ms. Koth?
I'd like to add, though, that the city was dissolved in May of 2023. It's
What
no
does
longer
it
a city.
mean? Well, we saw this coming, didn't we? Yeah.
Like a month ago, it was dissolved.
So what does it
Yeah.
mean if a city, can we find somebody in violation if they no longer exist?
I would have to look into that
Referred
I
to.
think there's sufficient evidence to show that, or to indicate that a violation has occurred, and I'll leave it to the Attorney General to figure out what the dissolution of the city means. So that's my motion.
Is there a second?
Second, with the comment that if you are statutorily obligated to hold an election, you need to hold the election. Even if there's only one person on the ballot, you still have to hold the election.
Yeah, I agree with that, but it didn't sound like a highly motivated group of people to have an election, so. I would simplify the motion to there's, we find a violation and that it be referred to the Attorney General's office.
Correct.
Is there any further discussion? There being none, all those in favor say aye. Aye. Opposed, no. Motion carries unanimously. All right, the next is case number 2022-336, Whitfield County vote buying. Can we have a report on this complaint?
The Secretary of State's office opened this investigation on November 4th, 2022, following a complaint from Ms. Valdez of Chattanooga, Tennessee, regarding Whitefield County resident Angelica Angeles. The complaint is regarding a raffle that Angeles advertised online regarding her eyelash business. The raffle offered participants a free full set and one retouch eyelash application. The requirements of the raffle were to share a selfie displaying a voting sticker and to follow her online business. The raffle winner was announced on November 8th, 2022. The investigator received the email from Ms. Meany with a notarized statement written by Ms. Angeles. In the statement, Ms. Angeles admits that she was the one that got the idea for the raffle, and it was to generate new customers for her business. She denied trying to influence a person to vote for any party or candidate. Based on the respondent's cooperation, online posting on her social media, and her written admission to having the idea and holding and completing the raffle, there is substantial evidence that the allegation of giving gifts for voting did occur. There is substantial evidence to support a violation of Georgia Code 21-570.
Is there any questions for the investigator? All right, there being none, is there a motion?
I find there's sufficient evidence to believe a violation has occurred, and therefore move to refer it to the Attorney General's office.
Is there a second? Second. It's been moved and seconded that, oh, is there any discussion? It's been moved and seconded that case number 2022-336 be referred to the Attorney General's office and that we find a violation. All those in favor say aye. Opposed, no. The motion carries unanimously. The next is case number 2020-078, which is DeKalb County illegal campaigning. Can we have a report on this investigation?
Okay, this case involved two individuals, one of which was a candidate, Andrew Bell and Benny Franklin. The office received information that an individual that we later identified as Benny Franklin was petitioning for Andrew Bell at the Peach Crest Elementary School on August 11, 2020. This location was an active voting precinct on this day, and Franklin's location was within the 150-foot rule according to OCGA 21-2-414, Sub A, Sub 1. There were photographs that were sent to us of this particular incident, which show that that vehicle was within that 150-foot space. Also, we were able to obtain a picture of what he was soliciting, and he was basically trying to get signatures for a petition. Ultimately, the investigator was not able to concretely locate a Benny Franklin, although from the driver's license picture that we have, we're pretty certain that it's the Benny Franklin in question, just looking at the pictures. But since he wasn't able to concretely identify him, he was listed, but it's not definitive. Ultimately, he spoke with Mr. Bell, And Mr. Bell basically said that Mr. Franklin was there on his behest, and he got permission from election representatives from DeKalb County to be where he was located, where Mr. Franklin was located. He basically didn't file it, but he reported on issues regarding the signatures later that he ultimately took to court, and subsequently, after going through different levels, it was dismissed. His complaint basically was that he got 2,210 signatures that he purported were valid. However, upon review by election personnel, they deemed that many of the signatures were not valid. And so because of that, he filed a legal action against the Secretary of State, basically saying that he received a letter saying that the signatures originally were valid, and ultimately that case was thrown out. So what we've ultimately found was that Andrew Bell and Benny Franklin were in violation of OCGA 21-2-414 sub A sub 1, restrictions on campaign activities, basically for where he was located and his conduct at that location.
Was, in 2020, was the prohibited distance 150 feet?
Yes, sir.
All right, any questions for the investigator? Not being any. And who are you? Who are you?
I'm Walter Bell.
So you must be related to Mr. Bell.
I can't hear you. It's muffled.
You must be related to Mr. Bell.
I'm his father.
And can we give him a microphone?
It's flashing.
Yes, sir. Can they work again?
Testing? Okay.
Okay, we got you.
Yes, I'm Andrew Bell's father. He is out of town. He wasn't able to attend. He only received his notice on the 9th, and he gave me this letter to either read to you or summarize to you regarding why he could not attend. Basically, it's that he did not receive proper 30-day notice, and I guess he rejects some of the findings by your investigators. Now, he sent the notarized version of this letter to your office at Suite 802, 2 Martin Luther King Drive. And basically, I have the letter here that's signed. I can read it to you or summarize it to you, whatever you want. But,
No, Mr. Bell, is what he's asking for is a continuance so that we hear it at a later meeting?
yes, sir, I would like, I think he would like a continuance.
Then I'm going to grant the continuance, and we will hear it at the next meeting. We'll hear it at the next meeting.
Say it again, sir. It's kind of muffled. I am, but just have hearing part. Okay, good. Thank you, sir.
Thank you, Mr. Bell. All right, now we are back to 2020-01. Is that right? Is that right? Or maybe it's what? No, it's 2020-80. Okay. Tab 13. Okay. Yes, tab 13.
That's the one that we had. 2020-001.
Yeah, that's what I thought. 2020-001. Mr. Mashburn confused me. This is the irregular signature.
Yes.
And so where we were is, and did you all have a chance to review the transcript? And I need to check on something. So we have we are Teresa Davis, correct? Yes, Teresa Davis. All right. So where we left off was that we were asking for, we're going to take these up individually because our experience with a couple of them is that we got more information as we heard the report. So what we were doing is we were down to Teresa Davis. And one of the principal issues, for example, with her is it says Teresa Davis stated during an interview that she probably signed her husband's ballot.
Right.
And we don't know what, when the person you interviewed, when Teresa Davis said that, did she mean she signed her name to her husband's ballot or her husband's name?
I believe she signed her husband's name to his ballot because he had medical problems.
All right. Any other questions about Teresa Davis then?
Was her testimony consistent with what you?
I did not interview her.
Oh.
It was part of the combined investigation.
Okay.
And that's what it said when I did a summary of that investigation or that interview. It just said he had medical problems.
So is there a motion for Teresa Davis?
I move that we refer Ms. Davis to the Attorney General's office.
All right. It's been moved and seconded that Teresa Davis, the complaint against her, be referred to the Attorney General's office. Is there any discussion? There not being any, all those in favor of the motion say aye.
Aye.
Opposed, no. Then the motion is unanimous. Next is Lydell Harris. This is Mr. Harris stated that she probably signed her husband's oath. And the question is, did she sign her name or her husband's name?
She signed his name because he had to work and he couldn't get off in time to go vote.
All right. Any further questions about Mr. Harris?
Is there any evidence on the record when they received that ballot?
I'd have to pull the documents.
Okay. Thank you.
And the documents, unfortunately, I thought they're in a big, of course, with 87 pages. So it's in our office.
No, that's quite all right. For our purposes.
Is there a motion for Mr. Harris?
Move that be referred to the Attorney General's office.
You look up Teresa Davis.
It's been moved and seconded that we find a violation and refer this matter to the Attorney General's office. Is there any discussion?
When we get back, I'll look it up.
There being none, all those in favor of the motion say aye. All those opposed, no. It passes. Next is Martha Baylor.
Okay. This was a mother of a son that had some disabilities. She signed his name to the absentee ballot. She got notified because it was rejected. She went down there and talked with them, and they told her the correct procedure. He was issued another ballot. He was allowed to sign it, and his vote counted. I think it was just a misunderstanding on her behalf because he's got some type of disability. Special needs, it says.
So does that mean she did what the election officials told her to do?
Right, after the first one was rejected, when it sent back in, it was rejected because of signature mismatch. Either they contacted her or she contacted them. They issued him another ballot, and she allowed him to make his mark and his vote counted.
Any further questions for the investigators? Is there a motion?
I think this would benefit just from a letter of instruction. I don't see the advantage of any benefit of it going to the Attorney General's office. I think it's unlikely to occur, and she's clued into how it should work. So I move that this be closed with a letter of instruction.
I mean, to find a violation and that we issue a letter of instruction? All right. Has that been seconded? It's been moved and seconded that we find a violation and send to Ms. Baylor a letter of instruction. Is there any further discussion? There not being any, all those in favor say aye. Aye. Opposed, no. It passes unanimously. Joel Wallace.
This was where he assisted Joan Blackman with her absentee ballot. He actually signed it for her, and she advised she allowed him to do it because his handwriting was neater.
And did he sign her name?
Yes, yes, Your Honor.
Right. With her consent and at her request?
Yes, Your Honor.
Did you know if she watched him sign it?
I don't believe another investigator conducted that interview.
Okay. Is there a motion on Joel Wallace's complaint?
I would move that Joel Wallace and Joan Blackman be referred, although she is not listed as a respondent, so I don't think that she has not had proper notice. So I actually would like to hold this, to continue this particular case, because I think when a voter abjures someone else to violate the law on their behalf, there needs to be some sort of recourse for them as well. So I would move that we continue this one particular case so that we can also provide notice to Ms. Blackman.
Well, if Ms., well, can we move forward on Mr. Wallace?
I'm fine with that, yes.
Let's do that.
Okay, so I move that we refer Mr. Wallace to the Attorney General's office, but request that we open an investigation for Ms. Blackman.
So the motion is to find a violation by Mr. Wallace and to refer to the Attorney General's office. Is there a second? Second. Is there any further discussion? There being none, all those in favor of the motion say aye. Aye. All those opposed, no. Passes unanimously. And we would request, Sarah, that we open an investigation of Ms. Blackman and get her story about the circumstances and why did she not do something to indicate, why didn't she sign her own signature even though it wasn't neat? Why did she ask somebody else to do it for her?
Yep. Mm-hmm. Yeah.
The next is Naomi Lupton.
She requested the absentee ballot for her son. She stated that he had moved to the University of Alabama, and she said instead of her taking the time to have him fill the absentee ballot out, she completed it and signed his name because she knew how he was going to vote, and she returned it to the elections office.
I have no question.
Any questions?
I believe there's sufficient evidence to indicate that a violation has occurred and move to refer this to the Attorney General's office.
Is there a second?
Second.
Any further discussion? All those in favor of the motion, say aye.
Aye.
All those opposed, no. And that passes unanimously. Yeah, I would say this as a dad. I would never presume to know how my kids are going to vote. Talk about a parachuting parent. The next is Samuel Reed. Could you brief us on that, please?
Okay, sir. He assisted his sister to vote her absentee ballot. He signed her name on the oath envelope because his sister's hands were shaking and she could not sign her name.
So Mr. Reed is Mrs. Reed's husband. Do we know that?
It's her brother.
Brother. See, it's interesting when you look at so many of these, you see the risk of us saying, well, it's okay in this instance, it's okay in that instance. I mean, the process is that if your penmanship is shaky or you have a hard time writing, that you can always make a mark, and then that can be verified by somebody.
Well, and now it can be cured.
And now,
So if you sign your own ballot,
right.
and the clerk says no, you get a message now under the new laws that there was a mismatch and you need to cure it. And so,
But even back then when we didn't have that, there's
even less reason for it now.
this sort of, I'm going to let me do it the way I think I ought to be able to do it as opposed to the way I should do it. So, is there a motion?
I move that we refer this to the Attorney General's office with instructions that they dispose of it with, we would be inclined to dispose of it with a letter from the Attorney General's office, but obviously further investigation.
I don't think the Attorney General's office sends letters, do they?
No, letter of instruction.
Right.
But I mean, there are a range of possible civil penalties that he's not necessarily on.
Yeah. Okay.
Thank you for the Department of Criminology. I move that we refer this to the Attorney General's office for further investigation.
All right. So the motion is that we find a violation referred to the Attorney General's office. Is there any further discussion? If not, all those in favor say aye.
Aye.
All those opposed, no. It passes unanimously. Next is Audra Brooks Roberts.
What was that name again, Your Honor?
I got it.
Audra Brooks Roberts.
There is evidence to suggest that she violated OCGA 21-2385 sub A, and that during the November 6, 2018 general election, the Richmond County Elections Office received an absentee ballot in the name of Bernard Roberts. The absentee ballot was rejected because of a signature mismatch. During the interview of Audra Brooks Roberts, she admitted signing her name to her husband's oath envelope. Mrs. Roberts stated she was trying to help her husband out, and she promised not to do it again.
Is there any questions of the investigators? No.
To clarify in this case, she signed her own name?
No, she signed her husband's name.
Oh, she has signed her husband's name. Okay, thank you, thank you.
Wait,
No. She's admitted
Wait.
signing her name.
Signing her name
To her.
Oh, I'm
to her
sorry.
husband's oath envelope.
Correction.
So she signed her name.
She signed her name, I'm sorry.
okay, so when somebody signs their own name, we've been sending letters of instruction, right?
Right.
Okay, so I move that this matter find a violation and send a letter of instruction.
Is there a second?
And she promised not to do it again as well, so. She got the point.
Yeah. All those in favor of the motion say aye.
Aye.
All those opposed, no. The motion passes unanimously. The next is Janet Price.
Okay. She assisted her mother to vote her absentee ballot because she was disabled, and her Mother could not sign her name on the oath envelope, so she marked where her mother was supposed to sign her name, she marked an X for her mother. And she also, the daughter signed at the bottom portion that she assisted her.
There's always a little twist, isn't there?
Is there any indication in your investigation that the mother would have been capable of making the X herself? Because that, to me, is the only violation whatsoever, because as Ms. Price signed as an assistant, that is wholly within the scope of her.
It says that the mother was disabled and she could not sign her
Yeah,
name
could
on
not
the
sign.
envelope.
Okay,
Disabled and could
Right.
not.
thank you.
It seems a reasonable position that if your mother can't do it, you can't sign her name because it might be deceptive that she could sign her name. And this was the most that she could do, and she wanted to make it clear that it was just a mark. But then she acknowledged that she helped.
I'm having trouble finding a violation on this one. I think she tried to do what she thought she ought to do, and it's not just relying on the ignorance of the law as a defense, but I think she tried her best to do what she thought she ought to do.
And she wasn't trying to deceive
She wasn't
anybody.
trying to deceive anybody, so I think I'll make a motion to dismiss it.
Is there a second?
Second.
Is there any discussion? All those in favor say aye.
Aye.
All those opposed, no. The motion carries unanimously. Now I'll ask my fellow board members, did I miss any of these? Did I miss any of these?
I don't think so.
Okay. I think that's the last thing we had on the agenda for today. Did anybody sign up to make public comments? Or are we going to do that all tomorrow? Okay. Then I'm going to adjourn the meeting until tomorrow. We will reconvene at 9 o'clock.